Case number 25-05080 Vibe Credit Union versus Teresa Davis Seals.
All right, appearances for the record, please.
Good morning, Your Honor. Elizabeth Butler, P80956 for Plaintiff Vibe Credit Union.
All right, good morning, Ms. Butler. And ma'am, what is your name?
My name is Teresa Davis Seals.
Okay, and good morning to you as well. Today is the date scheduled for 2 hearings, I see. We have a motion for summary disposition that was filed by the plaintiff, and then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it basically has come from me, from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be having this whole case situation to begin with. I tried working with that credit union one-on-one myself. It was not necessary for them to take this route. And now they have put her out here not equipped because she doesn't have any information. They didn't give her any. And now she wants to use me to work against me, which is crazy. This is why she wants this meeting today. She wants to hear additional information. And I purposely left my information at home. I have additional information other than this makeshift packet that she put together. And I purposely didn't bring it because, as I stated, I want to hear more about her affiliation with this company, and to let her know that the information that she does have is inaccurate.
Before we even get into the legal weeds of this case, you need to understand one thing right away. This is a textbook example of how confidence without preparation can absolutely derail your entire argument in court. Today's case pits a credit union against Teresa Davis Seals, who firmly believes she's being taken advantage of, not just financially but procedurally. She walks into court convinced the system is stacked against her, convinced the opposing attorney has no case, and convinced she holds all the power, despite showing up without the very evidence she claims proves everything. This isn't just a debt case. This is a mindset case. A clash between legal reality and personal belief. On one side, you've got trained counsel following procedure. On the other, a defendant who believes withholding information somehow gives her leverage. And as you're about to see, that belief is going to collide head-on with courtroom rules that don't care about feelings, suspicion, or frustration. So the question becomes, is she exposing corruption or sabotaging herself in real time? Stick around because this hearing goes exactly where experienced court watchers expect, and nowhere near where she thinks it will.
Okay. Well, now you've asked me to dismiss the case. And in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed the case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's a process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want, any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So,
Your Honor, can I say something else? I just want to bring out all of the rest of my feelings and information and everything concerning this case on September the 25th for the trial. As I stated before, the reason I don't want to keep giving information pertaining to Ms. Butler here is because she has no information and she's trying to use me to build the case.
ma'am, that's okay. That happens.
You
You
could be talking to them, not me.
Well, let me say this. It's if this case gets to trial, it is their burden to prove the case. But they can do that by any type of information, whether they got it from you, whether they got it from their client, the credit union, whether they got it from answers that were filed to interrogatories or your response to the complaint. That's okay. That's the way a lawsuit progresses. So it's not like she's doing anything wrong. But if she is using information that she obtained from you,
Well, Your Honor, she's not giving me any. When this
did you ask for any information?
Yes, but
Okay.
she didn't even answer her phone when I called.
Right here is where the entire tone of the hearing gets set, and it's subtle but important. Notice how the defendant doesn't start with legal arguments. She starts with intentions, suspicions, and personal grievances. She repeatedly insists the plaintiff's attorney has no information, while simultaneously admitting that the information came from her. That contradiction matters. In court, it's not about how unfair something feels, it's about what can be proven and how it's presented. Another key issue here is her belief that the attorney's role somehow invalidates the case. She seems to think that because she personally didn't hire or deal with this lawyer, the lawyer's involvement is improper. That's not how representation works. Attorneys don't need permission from the opposing party, they need authority from their client. And the credit union clearly granted that. Ask yourself this: if believing something is ridiculous were enough to dismiss a case, would courts ever function? This is where emotion starts replacing strategy, and courts are not built for that.
Well, ma'am, let me tell you, there is a written discovery. I don't even know if the court had ordered it before, but if I did, there's written discovery that you can use to actually ask for information. Now, from what I'm seeing here, this got filed fairly quickly, this motion. So I'm not even sure that we even did a scheduling order for discovery yet. They filed their motion for summary disposition, I think, before we even got to any of that. And I'm not even sure if you went, maybe you went to mediation. You did go to mediation. Well, at least it was ordered in July. Let's see if you went. I don't know.
Yes, Your Honor, we did go to
We had
mediation.
mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14th.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was giving credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting with the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to
Let
just.
me interrupt you a minute. I'm looking on my electronic filing and I see the motion itself, but I don't see, let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and a proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's that. Well, no, here's the exhibits. Okay, let's see if I got a brief with it. Okay, I've got all of the exhibits that you've attached right here. And it just says exhibits, but there's no motion. Let's see, notice of hearing there's no brief. I've got the motion, which is just your standard motion, but I don't have the argument. Do you know what date that you filed the brief?
On August 18th, the same day we filed the motion and those exhibits.
Okay.
Have
So let me-
filed.
This moment is critical, and honestly, it's where things quietly fall apart for the defense. The judge doesn't argue. He doesn't scold. He asks the simplest, most devastating question possible. Can you prove it? And the answer is no, not because the evidence doesn't exist, but because it was intentionally left at home. That's not a legal strategy. That's a gamble. Courts don't reward withheld evidence. They don't pause proceedings to accommodate tactics based on suspicion. Judges operate on what's in front of them, not what someone claims they could have brought. And when the judge explains that dismissal requires a legal basis, not frustration, not distrust, not dissatisfaction, you can hear the gap between expectation and reality widen. Let this sink in. Believing the system is unfair does not exempt you from its rules. Do you think the judge is being patient here, or simply giving her enough rope to explain herself fully?
let me look at everything from August 18th. So here's the motion. And the motion does not have anything else attached to it. It's just got a motion. And it appears to be about 2 pages. Then there's a notice of hearing from the 18th also. And that's 1 page with a date to be determined by the court. There's a proof of service from the 18th, which says everything was served on August the 18th. That's also just 1 page. Then on the 18th, here is a proposed order. That's 1 page. Then the next document. Aha! There it is. I must have missed it before. Here's the brief.
No problem, Your Honor.
Okay. All right, go ahead with that, your argument then. You've got your documents attached. I see those.
Yes, Your Honor. This relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers, provide credit union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't filed a response to the motion. Maybe if you want to consider her letter a response to the motion, she still has not presented any genuine issues of material fact that would justify a trial, nor has she stated any valid defenses. This motion is under 2.116, C9 and C10. If she doesn't present anything that would contest this balance, there really isn't much more for the court to review based on what we've already provided. That's why we ask that this court consider denying Ms. Davis-Steele's motion to dismiss and granting this motion for summary disposition. Again, there's really nothing to review further at a trial.
This is one of those rare moments where the judge essentially gives a free legal education, and it's flying right past the defendant. What he's explaining is discovery, one of the most fundamental processes in civil litigation. Both sides are allowed to request information. Both sides can use information obtained from the other. That's not sneaky. That's not manipulation. That's the backbone of how lawsuits move forward. What's striking is how the defendant frames cooperation as vulnerability. She believes providing information builds the case against her, when in reality refusing to engage properly weakens her credibility. Courts expect participation, not resistance disguised as principle. When the judge calmly states, "That's technically okay," he's shutting down the core of her argument, politely but decisively. Here's the real question. How many people walk into court thinking secrecy equals strength, only to learn transparency is mandatory?
All right, thank you so much. Okay, so Ms. Davis-Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union. And that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were credited for any payments that you had previously stated that you made, and that there was a prior loan, and then you got this new loan for debt consolidation. And they verified that all of your prior payments were indeed credited to the other loan. And this is a new loan. And that you've admitted that you pretty much owe this loan. There's no question there that you owe that debt. You had missed a couple payments, so that's the default. And otherwise, she says she's checked her balances, and this is the correct amount that's due, so that there really is no issue to go to trial on. And if there's no issue to go to trial on, we could enter judgment for the credit union today, because there's no issue. A trial is held when there are actual issues that we're not sure, well, what's the facts? This
Okay,
case, she argues, these are the facts. No one's disputing the facts.
I'm
So-
disputing. Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit
Ma'am, there's
union.
no evidence of that.
That they have. The paperwork that I,
excuse
let me finish
me.
talking. Your
I
Honor.
need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm to represent the credit union, because the credit union is trying to collect a debt. And they typically do hire debt collection firms to do that. So
Okay,
you
Your
have
Honor,
to-
let me
ma'am,
finish. Let me finish.
Ma'am, you can't say that to the judge.
listen,
Okay,
I'm sorry. I'm sorry.
Okay,
I'm not there,
okay.
and I'm not going to try to overtalk you.
Okay, I'm sorry, Your Honor.
And I'm the one that knows what's going on. I understand the law and I understand this process. And I've looked at these documents and I'm trying to explain it to you. But if you want to overtalk me, that's not going to work. Now, I'm fully happy to listen to anything you have to say. That I am willing to do. But if it's not right, I'm going to have to tell you that. And we got to move forward from
I
there.
understand.
Okay, go ahead.
Okay, so here's the whole situation. I took out the loan and I did that. It was a double loan. I started with one. They merged that first one in with the second one. Became a combined one loan.
And here's where the argument fully leaves the legal lane and drifts into personal grievance territory. Complaining about unanswered phone calls in a courtroom is like complaining about bad customer service during a trial. It's irrelevant. The judge's response is surgical. Discovery doesn't happen through missed calls, voicemails, or informal outreach. It happens in writing through formal requests under court rules. What makes this moment especially telling is that the judge isn't even saying she's wrong emotionally, he's saying she's wrong procedurally. Courts don't operate on vibes or anecdotes. They operate on filings, deadlines, and documented requests. And when the judge explains that discovery may not have even formally begun yet, it undercuts the entire accusation that the plaintiff's attorney is acting improperly. At this point, ask yourself, is this about justice or about control?
Out of that one loan, I have paid over $8,000 and plus dollars for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I
me.
have it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
Well, it's not accurate. They have false information regarding what I have paid, and everything else that she's saying about this, what they have done is false and against what is actually true.
Okay,
and
ma'am.
I wanted to bring out all of my information
You don't have
during
it.
the trial. That's what I thought I could do.
We don't